Minor. Is that your name, son? You all alone, Kenneth?
Father deceased. Mother working in a secretarial capacity at the high school. Now, she was notified to be here at 2. It's after 3 now.
Now, you don't need to worry, Kenny. This is no criminal court. We're here to help you. Before we start, it's my duty to remind you of your right to counsel. Do you want a lawyer?
My mother tried to get one, but she couldn't.
If you want a lawyer, we'll get you one. Free. The public defender.
Judge, I'm afraid the public defenders are quite busy for the next few weeks.
It seems the public defender's kind of overloaded. But if you don't mind waiting a few days...
You mean go back to the juvenile home?
Look, Kenny, all we're after in this court is the facts. Sometimes a lawyer can help bring these facts out, but no lawyer in the world could change them. So you tell me, do you want to wait, or do you want to go ahead and trust us?
I don't want to go back to the juvenile home. Oh, okay, let's go ahead.
Kenny, you know Mr. Austin, the probation officer, don't you? Well, he's filed a petition with this court in your interest. Now, I want you to know what's in this petition. Frank?
Be it known that Kenneth Carter, Jr., residing at 521 North Cedar Street in the township of Amos, Texas, is a minor under 21 years of age, and that for the following reasons, the said minor is in need of the protection of this court. First, it is alleged that on November 24th, said minor committed grand theft auto in allegedly removing an automobile belonging to one Vern Merritt from the driveway of his home at 63 Hillside Drive. Second, it is alleged that said minor subsequently drove said vehicle in a reckless manner, far exceeding the speed limit, allegedly causing a collision with a vehicle driven by one Walter B. Scott. Third, it is alleged that the damage loss to both vehicles is total, and that said Walter B. Scott sustained serious personal injury. For these reasons, the Youth Authority petitions this court to protect the said minor in the following manner. 1, by declaring Kenneth Carter, Jr. a ward of this court. 2, by issuing an order for his care and custody as a delinquent.
Judd, for the defense.
Kenny, I want you to come up here and swear to Almighty God that every statement you make in this courtroom is the truth, the whole truth, and nothing but the truth.
Your Honor, I'm Mrs. Carter, Kenneth's mother.
It's all right, Kenny. You can go to your mother.
Oh, Kenny. I'm so sorry I'm late, but they didn't let me know until just a little while ago.
Doesn't matter, they're just getting started.
The bailiff will show you to a seat. Kenny, now, please take your seat. Kenny, you know why you're up for this hearing, don't you?
What kind of the accident?
On the evening of November 24th, you hit another car, right?
It wasn't my fault. He came backing out of the driveway. I hit the brakes, but they wouldn't grab.
I have a statement from the first police officer to arrive at the scene of the accident. Now, he estimates the speed of the sports car which Kenneth was driving at a minimum of 60 miles an hour. The speed limit on Hillside is 20.
60 miles an hour in a 20-mile zone?
I was going downhill. I couldn't help it. I tried to slow down, but I couldn't.
What were you doing in that car in the first place, Kenny?
Kenny, why don't you tell him? You work for the Merritts.
Please, Mama.
Does your job with the Merritts have anything to do with driving?
No.
Kenny, did you steal that car?
No, I didn't.
Now, look, Kenny, we want to be fair and help you, but you've got to cooperate. You were driving a car that belonged to Mr. Merritt, weren't you? I want to hear your answer, son. Yes or no?
Yes.
And you were driving down Hillside at a lot faster than the speed limit, yes or no?
Yes.
And did you have Mr. Merritt's permission to drive that car, yes or no?
I did.
Yes or no, Kenny?
Judge,
Yes, Frank.
I spoke to Mr. Merritt about this. Neither he nor Mrs. Merritt ever gave the boy permission to drive the car.
Do you want to challenge that statement, Kenny? You know that taking property that doesn't belong to you is stealing, don't you?
I guess so.
You know so. And all the squirming and weaseling in the world won't change it. You stole that $8,000 car and drove it like a darn fool hot rod and wrecked it. And wrecked another car and hurt the driver of the other car to boot, and you know it. Now, under the circumstances, Kenneth Carter, Jr., I have no choice but to find you delinquent, as requested by the petition, and to place you in the care and the custody of this court until your 21st birthday.
Please. Please, just a minute, please. What's going to happen to Kenny now?
He'll be sent to the county vocational school for boys.
And kept there till he's 21? Judge, you're sentencing him to 3.5 years.
Mrs. Carter, I think that's best for the boy.
He would have been there this afternoon, graduating with his class. This hadn't happened. Right after their pictures were taken and their class rings ordered. But it isn't fair to bother you with this, Mr. Judd. Certainly not when you have your mind on your commencement day address.
It's not only fair, it's poetic justice. I was telling your high school principal that my commencement day address would be about the virtues of the law as a career until he hit me with the sorry state of the profession in my own hometown. You really couldn't find a lawyer capable of handling your son's case?
Mr. Judd, nobody in Amos seems to know very much about juvenile law. I suppose that's hard to believe.
Well, no. Not when you stop to think about it, as I've just been forced to do. See, juvenile defendants have less money than adult criminal defendants who have less money than corporations. So the least rewarding branch of the profession for a bright young law student to go into is juvenile law. Thank you, Jimmy. Tell me a little bit about Kenny.
Well, he's always been a good kid. I'm not just saying that because I'm his mother. You can ask any of his teachers. He's never given anyone any trouble. His grades, his conduct. Well, just to show you how responsible he is. When his father died 6 months ago, Kenny pitched right in, went out and got himself a job for after school.
Which is when all the trouble started, if you ask me.
Ginny, I didn't hear anyone ask you.
Well, if Mr. Judd wants to know about Kenny, why don't we tell it like it is?
Well, how is it, Jimmy?
Well, if you knew my brother before... Well, I mean, he was all right. He really was. Then he went to work for that Mrs. Merritt. And now it's like nobody's around anymore.
What she's trying to say is that between his schoolwork and his job, he had too much on his mind to pay much attention to her.
Well, he sure had something on his mind. He looked right past me.
Sounds like another generation gap between 15-year-olds and 17-year-olds.
It was the money gap.
Come on, Ginny. That, Mr. Judd, is the generation gap, the real thing.
Which I've got to face at commencement, 500 strong. Oh, I'd better get ready. Who was the judge at Kenny's hearing?
Edgar Brown.
Edgar Brown? The tax appraiser? When did he get to be judge of the Juvenile Court?
When he helped some friends get elected to the state legislature.
I must try to get home more often.
I can't remember every case, Clint, with all the kids that come through this court every week. There are 2 of us juvenile court judges, and we can't hardly keep up with the load. You won't believe this, but I even find myself cracking the law book some nights. Oh, here. Kenneth Carter, Jr.
nothing here but the petition, a note on adjudication, and the police report.
What more'd you expect?
Well, something that would tell me what the hearing was all about, a transcript.
Hold it, Clint. This is juvenile court. We're not in your league.
You never make transcripts of hearings?
Not unless there's a very special reason.
Well, maybe his counsel knows the details or kept a record. Who would that be, the public defender?
As I recall, the boy waived his right to counsel. And before you start clobbering me with the Bill of Rights, Clint, every kid who comes to my court is told about his right to counsel first thing. If they don't have it, it's because they don't want it.
And how did you decide he was guilty? Who cross-examined the witnesses?
In juvenile court, Clint, nobody's guilty. Nobody's even charged with a crime. If a kid breaks the law, and it's proved, he's a delinquent, not a criminal.
Now, I'm aware of that fine theoretical distinction. But what does it boil down to in practice? Kenny Carter is not a criminal, but he's locked up for 3.5 years.
You think that's too much punishment for stealing an $8,000 automobile? Smashing it up and the driver of the other car, too?
Was all this proved at the hearing?
Proved? The boy admitted it.
Admission is not proof. Why did he admit it? Under what circumstances? Was he advised of his privilege of silence, of his right not to incriminate himself?
You're still talking like this was a criminal court, Clint. It's a different ballpark with different rules.
But the name of the game is the same. It's called justice.
If you don't think Kenny Carter got a fair shake in my court, why don't you ask him what he thinks?
Well, because as it happens, I'm due back in Houston. But I have a very capable associate who will do just that, Ed. As soon as he can get here.
I don't think you understand what I'm here for, Kenny. I'm here to help you.
I'm just like Judge Brown. All he wanted to do was help me. For 3.5 years in this place.
Kenny, there is a difference between a judge and a lawyer. At least you can tell me whatever you told the judge.
I didn't tell him anything.
Well, you admitted to the theft of the car, to reckless driving, to causing an accident.
Nothing! I didn't admit to anything because I didn't do anything, you understand?
Frankly, no.
May have sounded like I was admitting things. But that's on account of the way they ask you those questions in court. If you answer no, it turns out you're a liar. If you answer yes, you're guilty.
Kenny, there's no doubt that these things happen. Now, when the judge came to ask you how you got involved in them, what did you tell him?
Told him I didn't know.
And you expected him to...
Right! Why not? Everybody's supposed to be innocent until proven guilty. Isn't that true?
Kenny, look. If you honestly feel that you didn't get a fair shake, then we can file habeas corpus in Superior Court and maybe get a new hearing. Now, do you want that? All right, from now on, I'm your lawyer. Now, Brian, I want you to tell me what happened that night.
But I thought you agreed that I'm right, that I don't have to tell anything I don't want to tell.
Oh, well, you don't have to say anything to the court, Kenny. I'm asking you to tell me, your lawyer, in the strictest of confidence.
Why?
Well, because, well, there's no point in everybody knocking themselves out to try and get you a new hearing if it isn't going to change anything. If you're going to still refuse to talk about the car theft or anything connected with it.
Don't knock yourself out. Don't do anything for me. I'll do my 3.5 years, that's all. All right with you?
Yes, operator, I want to call long distance, Houston, Texas, person to person to Mr. Clinton Judd. The number there is... Yes, fine. All right, operator, I'll wait right here. Thank you.
Mr. Caldwell.
Yeah.
I saw you with Kenny. I'm Frank Austin, the probation officer on the case.
Oh, yes.
What do you and Mr. Judd intend to do?
Well, Mr. Austin, all I can tell you at this time is that I would like very much to talk with you. Right now, I would just like to go over with you the facts in the case.
Well, the facts, Mr. Caldwell, are that the judge takes over for the parents on the presumption that the parents have failed. Otherwise, the boy wouldn't be in juvenile court.
Well, Mr. Austin...
And in the boy's best interests, that is the long-range best interest for the boy, I am not going to answer any further questions, Mr. Caldwell.
Now, that is where you are mistaken, Mr. Austin. Because you will answer them, and under oath, in Superior Court.
I submit, Your Honor, that the importance of this hearing goes far beyond the personal fate of Kenneth Carter, Jr. Consider that the juvenile court system was created and exists in this country for these highly commendable aims: to give special protection to children, precisely because they are children, to treat them as children, not as hardened criminals when they come in conflict with the law. But if under the guise of protecting them, we deny them the basic rights that we grant to every common criminal adult, then these children are getting neither the protection of their own courts nor the benefit of adult courts. In short, they're getting the worst of both worlds. And that's not a phrase I invented for the occasion. Those are the words of a justice of the Supreme Court of the United States. I maintain, Your Honor, that in his hearing, Kenneth Carter, Jr. was deprived of his constitutional rights under law as follows: the right to proper notice of the charges against him, the right to counsel, the right to confront and cross-examine witnesses, the right to silence under the privilege against self-incrimination, and the right to a transcript of the proceedings of his hearing. For these reasons, we do petition this court to set aside the decision reached at that hearing.
Your Honor, with all due respect to the moral fervor of Mr. Judd, I point out that Kenneth Carter, Jr. was brought before Juvenile Court for very serious violations of several statutes.
For being accused of such violations, Your Honor. No case was actually proved against him, because a case can't be proved without the basic rights of due process, which Mr. Vega here, in his normal capacity of Assistant District Attorney, grants to every adult defendant he prosecutes.
Mr. Judd, this being a hearing and not a trial, I'm going to interrupt your argumentations at this point and ask if you intend to call witnesses.
I do, Your Honor.
All right, then. Proceed with your witnesses.
Mr. Austin, how and when was Mrs. Carter informed of the time and place of her son's hearing in juvenile court?
I phoned her at her job on the morning of the hearing.
And about what time in the morning?
Around 11:30, which is when I found out about it.
And for what time was the hearing scheduled?
2 p.m.
In other words, Your Honor, this woman, working at a job to support her children, was given only 2.5 hours' notice.
Why was that, Mr. Austin?
Well, we just asked her if it was convenient, and she said yes.
To be fair about this, Your Honor, let Mr. Austin say whether or not anything was done to accommodate Mrs. Carter.
Yes, sir. When she didn't appear on time, we switched several cases around and gave her an extra hour.
But didn't the hearing start without her?
Well, we waited as long as we could.
Did you phone her again to find out why she was late?
We have 2 telephone lines for the whole building, and they're both busy most of the time.
Well, then she couldn't call you either, and yet you went ahead without her.
Well, now, if you knew how many parents swear they'll be there and never show up at all. And besides, she got there just a few minutes later. She missed practically nothing.
Oh, was she there when Kenny waived his right to counsel?
No, but her presence wouldn't have changed anything. The boy just didn't want to wait until the public defender would be available.
Mr. Austin, how much of a wait was involved?
Oh, about 3 or 4 days, Your Honor.
Or possibly longer?
Well, I couldn't say. Nobody could.
And where would Kenny have waited during this period that nobody could possibly estimate in advance?
In the juvenile detention home.
In close confinement, practically in prison. The same place where he was held while waiting for his hearing to come up?
That's right.
For how many days?
17.
Kenny was locked up for 17 days waiting for his hearing and would have had to wait 4 or 5 or nobody knows how many days more in order to exercise his constitutional right to counsel. Is that correct?
Well, now, in all fairness to Judge Brown, Mr. Judd, this is not his fault. This is a matter of the pressure of caseloads against available facilities and personnel, and Judge Brown does not control that, nor does any other individual.
Of course not, Your Honor. Least of all, an individual like Kenneth Carter, Jr., who was the victim of such pressure.
Objection.
I think I object to that myself.
Well, in that case, I'll withdraw it. Call my next witness, Judge Edgar Brown.
I wish you could sit in my court a few days and see those kids. They're in trouble, mixed up. What they need is someone who'll talk to them, listen to them. They need sympathy, not due process. You talk about separating the children from the criminals. That's exactly what we do. How? By running a court that's more informal. Maybe we don't dot every I and cross every T, but we give people a chance to talk, and we take their word for things. Nobody's jumping up and down every minute yelling objection. We started running juvenile court like a criminal court. Pretty soon it would get to be one. Now you take the question of a transcript. Used to be they were outright forbidden in juvenile courts. Why? To protect the child, his privacy, his future. Now you saw Kenny's file in my office. There are mighty few details in it, sure. He's not charged with any crimes. He's ruled a delinquent, not a criminal. And there's a big difference.
Is there? I mean, realistically, the file shows which sections of the penal code he violated.
But that file's confidential.
How confidential? I could look at it as his counsel. You could as judge. Mr. Austin could as probation officer. Who else could?
Nobody. Except, of course, duly authorized individuals from lawfully recognized bodies or agencies, like the FBI, for instance.
How about the police?
Them, too.
And the armed forces?
I guess so.
And possibly, under special conditions, still others? So that this protection of the child's privacy is something of a fiction, isn't it? In fact, a full transcript with all the details and explanations and possibly extenuating circumstances would actually give the child more real protection, wouldn't it?
Well, that's not for me to say.
All right, Judge Brown. Are you aware of a Supreme Court decision which upholds all the rights of due process in juvenile hearings, including the right to a transcript?
Sure, the Supreme Court makes decisions. But who's got the money for stenographers and office space and all the rest of it to carry them out? Don't you tell me to be a one-man extension of the Supreme Court. You tell the state legislature to put up the funds.
And does lack of funds also justify your accepting hearsay concerning the testimony of witnesses who were not present?
I don't follow that.
In what form was the testimony of one Vern Merritt to the effect that his car was stolen from his driveway?
In what form?
Mr. Merritt was not present at the hearing. Did he send a sworn affidavit?
No, that wasn't necessary. Frank Austin was under oath when he testified to his conversation with Mr. Merritt.
But not Mr. Merritt. And where did this conversation take place?
Frank called Mr. Merritt on the phone.
You accepted a telephone conversation as testimony?
Well, didn't I know for a doggone fact a probation officer was not going to lie to me?
Judge Brown, you didn't even know for a fact that the man the probation officer spoke to on the telephone was Vern Merritt.
Well, now, just one little minute.
If Your Honor, please.
Yes, Mr. Vega.
So happens that Mr. Vern Merritt, the gentleman whose position Mr. Judd is questioning, has arrived in court. In the interest of justice, may I call him to the stand? Mr. Merritt, did you in fact have such a conversation with Mr. Austin?
I certainly did.
Did you or did you not say that your car had been stolen from your driveway?
That is exactly what I told him.
Thank you very much. You may step down, Mr. Merritt.
Well, now, just a little minute. Don't I get to cross-examine?
I apologize for my oversight. You certainly may cross-examine, Mr. Judd.
Thank you. Mr. Merritt, the car in question, is it your car or your wife's?
Well, I bought it for Jean last Christmas, but it was registered in my name. I suppose that makes me the owner of an $8,000 piece of modern metal sculpture. In other words, twisted junk.
Did you ever give Kenneth Carter permission to drive the car?
No.
Did your wife ever give him such permission?
No, she did not.
You say she did not. But did you hear every conversation between your wife and Kenny Carter?
Of course not.
And then how can you say under oath that she never said anything to this boy that he might have construed as permission to borrow the car?
Well, I can't say that.
That's all, Mr. Merritt. You may step down.
And for the foregoing reasons, the court grants plaintiff's petition for a writ of habeas corpus, and Kenneth Carter, Jr. is remanded to the Juvenile Detention Home. This court also orders a new hearing in this case, to be scheduled at the earliest possible date. This court is adjourned.
Mr. Judd? Can I see you a minute privately?
Yeah?
You know, it doesn't pay to be quite that smart. By which I mean smart enough to get Judge Brown reversed, but not enough to do Kenneth any good.
And that remains to be seen at his new hearing, doesn't it?
Not really. The boy won't get off. He assaulted Mrs. Merritt.
He what?
He struck her, left her unconscious, and stole the car. Now that's what has to come out at the new hearing.
You never said that before.
Well, she didn't want to prosecute. And I've been trying to protect the kid. Judge Brown and I, taking the place of parents, trying to apply corrective discipline, holding back the kind of charge that could ruin his life. I tried to tell Caldwell that we are professionals with juveniles. You are not. Let us do our job. And now, you had to open Pandora's box.
Kenny, did you hit Mrs. Merritt?
Why? I mean, why do you want to ask me a question like that?
Because Mr. Austin says you did.
Well, him.
Kenny, we're going to operate under a new policy. It's called giving the client the benefit of any doubt, which means that I'll believe anything that you tell me as long as it makes sense.
Okay.
Okay, you say that you didn't steal that car.
Right.
But you were driving it, though.
We're sure.
Did Mrs. Merritt give you permission to take the car? New policy, remember, Kenny?
No, she didn't. I just took it.
And you don't consider that stealing?
I was going to bring it back. New policy.
You got a point.
It's still stealing?
Well, it all depends on why you took the car. Why did you?
I don't want to go into that. Do I absolutely have to give you a reason?
Well, Kenny, the judge at your new hearing is going to ask you the same question, and you're going to have a good answer. Don't you want to try it out on me first? All right. All right, you don't want to be defended. Have it your own way.
Mr. Caldwell, it was an accident.
Accident my foot. I've seen Clinton Judd pull that same stunt in the courtroom.
Well, if he can get away with it, why can't I? New policy?
You have another point.
I could tell you something I haven't told before.
Now, I'm listening.
This Mr. Scott, the guy who was my fault, got hurt in the accident?
Yeah.
You should have seen him jump out of his car and try and clobber me until the police drove up. Then he puts his hand back here and says, "Oh, my back."
What, are you trying to say that he faked that injury for insurance purposes?
People do that, don't they?
Well, that's a very interesting point about Scott. Although I don't know what bearing it has on your case, and I will look into it, there is something that I would like to get back to that is important.
Okay.
Did you hit Mrs. Merritt?
No, I didn't.
That's the absolute truth.
Listen, you're not going to believe me if I stand on my head on a stack of Bibles. If you really want to know if I hit Mrs. Merritt, why don't you ask her?
She's not at home.
Oh, can you tell me when you're expecting Mrs. Merritt?
I don't know. What do you have in mind?
Well, a few questions on the Kenneth Carter case. I have a couple for you, too, if you can spare a minute. Thank you.
Go ahead.
Why did you go to Kenny's hearing the other day?
Just interested. It was my car he wrecked, you know.
Yes, and it was your car during the time of the first hearing. But you weren't interested enough at that time. What makes the second hearing different? Shall I suggest a difference?
Well?
Walter B. Scott, the other party. Well, he recently filed suit against you for his injuries, didn't he?
What of it? I'm insured.
But are you insured for the full amount that Scott would receive if he wins?
He can't win. I'm not responsible for any damages caused by a person who stole my car, am I?
Probably not, if the car was stolen. But if this new hearing should show that Kenneth Carter didn't actually steal your car, well, then you would probably be held responsible for any and all damages.
But there's absolutely no possibility of that.
There was no possibility. But that was back when the kid was quietly hustled off the scene. But now that his case is going to be fully aired, Mr. Merritt, well, Walter B. Scott and his lawyers must feel there's some possibility now, or they wouldn't have filed suit.
Caldwell, I don't know what you're fishing for. And I don't even see any bait. So, if you'll excuse me.
What time did you say your wife was expected?
I didn't say. My wife is shopping. The stores are all open late tonight, and she never comes home till they close.
Hi.
Except when she wants to make a liar out of me.
Well, what did I do wrong now?
Well, not a thing, Mrs. Merritt.
I decided not to go shopping. I had the lights on the court. Well, Vern, why don't you bring our guest in and give him a drink?
Gene, this is Mr. Caldwell, Clinton Judd's associate.
Hello.
Be careful what you say. They're Kenny's lawyers.
Mrs. Merritt, Kenny's new trial is coming up.
Yes, so I heard.
And it would be a great deal of help to him if you could give me some idea of what he was doing around here before he took off in your car.
Didn't he tell you?
He gave me a half a dozen different stories.
He has a wild imagination.
He's a sick boy.
Now, he is a frightened boy, and I don't blame him. Now, he is facing 3.5 years in custody.
If I were the judge, I'd throw the key away.
Oh, come on, Vern. Just because he says the car brakes failed, who knows, maybe.
Gene, that's enough.
Look, I didn't come here to ask you information prejudicial to your lawsuit. Mrs. Merritt, I'm principally interested in one point. Did Kenny strike you?
Did what?
During the process of taking the car, did he assault you?
Oh, now, come on, Mr.
Caldwell.
Mr. Caldwell. That poor boy's in enough trouble as it is without my making a claim like that.
Well, why do you suppose that Mr. Austin, the probation officer, said that he did?
Are you asking me to explain why other people want to tell lies?
No, not exactly. But I don't see why a probation officer would lie about a thing like that.
You mean my wife is lying?
No, I didn't say that either. But it could be that Mrs. Merritt is a little overly sympathetic towards the boy.
Well, that would be to her credit, wouldn't it? What else do you want?
Well, I would like to know exactly what Mrs. Merritt was doing and where she was when the boy drove off in the car.
That's all you want. Well, let me answer you this way. The bar is closed.
All right. Mrs. Merritt, I'd like you to think about this between now and Monday.
What's Monday?
The boy's new hearing. You're invited. I'll see you in court. It's all right, I'll show myself up.
This is just great.
Oh, Vern, will you please tell me why you're so upset?
Scott is suing for $500,000.
Oh, we're insured, aren't we?
We are insured for $100,000. Whatever Scott gets above that, I've got to pay myself.
Kenny was working out back in the pool area, trimming some bushes. Around 5:30, I heard a car stop in the driveway. It was my husband, and I was surprised. He usually gets home much later than that. I hadn't done my marketing, so we decided to go shopping together. And we took my husband's car. My own car was in the carport when we left. When we got back, about an hour later, my car was gone, and so was Kenny. I didn't know what to think. And then I heard the phone ringing inside. I ran inside to answer it, and it was the police calling to say that my car had been in a wreck, and Kenny was arrested.
Mrs. Merritt, did Kenny ever show any unusual interest in your car before that day?
Oh, most boys like sports cars, don't they?
With all the extra gadgets and special controls that I've seen on high-powered European sports cars?
Yes. I never did figure out what some of them were for.
Do you think that someone who had not driven that model before could just get into it and immediately be able to drive it?
Well, I suppose if you know something about cars, the way boys like Kenny do.
Did Kenny ever drive that car before November 24th?
No, he didn't.
Mrs. Merritt, are you absolutely certain on this point?
I'm positive. He never drove the car before.
Now, returning to the previous point, is it your testimony that when your car was taken from your driveway, you were not at home?
Well, that...
You don't even care what happens to you.
Jane, shut up!
I won't shut up! Mr. Judd, she's lying. She's lying. Kenny did drive her car before. I saw him myself.
Your Honor!
All right. We'll have order and the hearing will resume. Mrs. Merritt, are you ready to return to the stand?
Yes, Your Honor. Your Honor, may I correct something that I said before?
Yes, certainly.
I said that Kenny never drove my car before November 24th. But my husband tells me I should have said as far as I know he didn't.
Meaning he might have driven it without your knowledge.
Yes. Kenny worked around the house lots of times when I wasn't home. And some of those times my car was parked there in the driveway with the keys in it. Well, which I shouldn't have done, but I did very often leave the keys in the car. So I don't know how many times he could have taken it.
Without your knowledge. And definitely without your permission. Is your answer yes?
Yes, Your Honor.
All right. Mr. Judd?
May I ask the court's indulgence for a moment? Thank you, Your Honor. How does it strike you, Mr. Austin? Is she trying to cover up something?
We're on opposite sides.
Mr. Austin, aren't we all really trying to act as the juvenile's parents?
Not anymore. Not since you turned this into a criminal court adversary procedure. Now, don't ask me for help.
Your Honor, in view of the late hour, may I ask the court be adjourned for the day?
All right. We stand adjourned until 10 a.m. tomorrow.
Oh, Mr. Merritt.
Yes?
How would you like to invite me to your, I understand, gracious home this evening about 8 o'clock?
Why should I?
Well, for openers, to avoid being charged with subornation of perjury.
And on one of the two occasions, Ginny was playing volleyball in the school courtyard when she saw Kenny drive by in your car.
Well, in other words, this is exactly what my wife suspected. The kid took the car without her knowledge.
No, that's not exactly the way it was, Mr. Merritt. Because Mrs. Merritt was in the seat right next to him.
Gee!
No! And this was witnessed not only by Ginny Carter, but by half a dozen of her friends playing volleyball with her. Look at Ginny Carter's brother driving the jazzy sports car, and wow, who's that sitting next to him?
Mrs. Merritt, I have those kids' names. I can call them all to the witness stand. And then I can call Frank Austin to the stand and ask him to explain under oath why he told us that Kenny struck you. The only logical answer is that you told him that Kenny struck you. And then I can call you to the stand and ask you under oath why you insist on hiding this, when your husband's position would even be improved in that $500,000 lawsuit that Scott has against him, for you to claim that Kenny struck you and stole the car. Why you insist that you were not home at the time. And if you don't tell the truth, Mrs. Merritt, you'll go to prison for perjury. Oh, it can happen. You can go from those pillows in this lovely home to a cot in Spindletop State Prison for Women. It can happen no later than 10 o'clock tomorrow morning. We'll say goodnight.
Well, Gene, what are you going to say in court?
Is that all you really want to know? What am I going to say in court?
I've got a possible $400,000 judgment against me, remember?
What do you want me to say in court?
You say what you said before. Half a dozen scatterbrained kids playing volleyball can't be that convincing. One probation officer could be mistaken. Say just what I told you to say. Can't you even do that, Gene?
No, I don't think so.
Oh, boy. Are you that scared, Gene?
Vern, do me a favor. As if maybe the last favor I'll ever ask of you. Don't show up in court tomorrow.
At the suggestion of Mr. Judd, I will not allow any spectators at this session.
Mrs. Merritt, I remind you that you're still under oath. Would you explain to the court, please, the nature of your relationship with Kenneth Carter, Jr.?
It was in the nature of an affair.
With a 17-and-a-half-year-old boy. And this is what you've been trying to keep out of this proceeding?
Do you blame me?
Whether I do or not, Mrs. Merritt, I'm obliged to ask you if this affair has any bearing on the events of November 24th.
Yes, it did.
Would you explain that to the court, please?
Well, I was home alone, as usual, except for Kenny working in the backyard. My husband telephoned to say that he'd be tied up at a dinner conference and he wouldn't be home until late. As usual. So when Kenny finished up and said he was going, I told him not to. To stay and have dinner with me. But he said he couldn't. I asked him why not. And finally he told me he had a date. That got me angry. I don't really know why, but it got me very angry. And so I wouldn't let him go.
By that you mean you restrained him physically?
Yes, I was holding on to him and he was pulling away. And I fell down and hit my head.
In the course of Kenny's struggle to get away?
Yes, I blacked out for a while. And when I came to, the car was gone and so was Kenny. And the police were telephoning to say there'd been this accident.
Mrs. Merritt, I'm trying to understand the reasons for all your sins of omission and commission affecting the entire future of this boy. Now, did you, for example, ever permit him to drive your car?
Yes, I let him take me to the market a couple of times, but that's all.
Will you kindly tell me why in the world you wouldn't tell the truth about that before?
Well, we have this $500,000 lawsuit, and my husband said it would be better for us if I claimed that I never gave him permission at all.
I have one more question, Your Honor. Do you now wish to tell the court anything about the condition of the brakes on your car?
They never were right. I was supposed to take the car back to the dealer. But I never did get around to it. Is there anything else I should say now?
No. You may go, Mrs. Merritt.
Thank you very much, Mrs. Merritt.
She wasn't moving. I was scared. I figured if I could get Dr. Collins, he's our family doctor, I could explain to him about her and me on the way back. I had trouble with the brakes. I was going downhill and the car kept picking up speed. And that guy came backing out of his driveway.
Kenny, will you tell me why you never said anything to Judge Brown or anyone else about your relationship with Mrs. Merritt?
I was ashamed to.
In my view, the weight of the testimony presented before this court is that Kenneth Carter, Jr., did not drive said automobile off with the intention of stealing it. And he may not have been responsible for the accident which followed. Therefore, the petition that said minor be declared delinquent in the ward of the court is denied.
Mr. Ross? Mr. Ross? You owe me an explanation. Didn't you know what was going on between Kenny and Mrs. Merritt?
She told me about the struggle when she was still upset enough to be telling the truth. Later on, I could see she carefully did not tell her husband, so I could make a pretty good guess.
And you didn't say a thing in your official capacity?
My official capacity was to protect the kid, not to let him get smeared for the rest of his life. Of course, I didn't know the whole story. Particularly that brilliant counsel would take over the case.
Mr. Austin, I did nothing more than any competent lawyer would have done. The point I wish you would see is the injustice of trying so many of these kids in juvenile court without lawyers and calling that protection of the young.
Well, how would you protect them? By feeding kids into the machinery of the ordinary criminal courts, where nobody cares what happens to them? Look, do you really think you did this kid any favors by getting him off scot-free, without any disciplinary correction?
He's not legally guilty of anything.
He was carrying on with a married woman. He lost his head, he took a car he couldn't handle properly, and he caused a very serious crash. Now, let me ask you this, Mr. Judd. How would you feel about seeing some other lawyer get him off, if you were the man he ran into?
This is Fox.